Hello all, a warm welcome to all of you as we stand at our second webinar session on the series NRI Guide to India Property Transactions. I'm Srilata, a chartered accountant and working with Advait in the team of Knowledge and Solutions. I have with me CA Krishna Upadhyay sir, co-founder of Advait iTech Private Limited. Welcome to you sir.
Thank you, Srilata.
Well, our previous webinar was on everything you need to know as an NRI, specifically before selling an India property, where we had covered various practical aspects of taxation, documentation, and key coordination things that you need to keep in mind as an NRI while executing such sale transactions. If you had missed attending it on live, you can watch the recorded webinar, which we have streamed on our YouTube channel. Today's webinar is focused on buying India properties. If you look at the recent trends, it shows that NRI's interest in Indian real estate is rising rapidly, with a clear shift from traditional metro cities to tier 2 cities. And this is naturally driven by affordability, which is supported by improving infrastructure, potential for long term returns, and of course, a growing desire to come back to roots with ongoing global uncertainties. These trends have also been highlighted by industry bodies like CREDI along with leading developers in India. If you see with this kind of trend, it becomes increasingly important for the growing number of NRIs interested in Indian real estate to be aware of certain key considerations before taking any buying decision. And there are multiple aspects to be evaluated, both from the angle of legal requirements and from non legal practical perspectives. With this background, we have structured today's discussion into three quick sections. First and foremost, the investment rationale, which along with property registrations and documentation aspects. Secondly, we will touch upon certain critical taxation matters that NRIs should be aware of. And third, which is often the most interesting part, which is FEMA regulations along with funding and repatriation aspects. When we talk about investment rationale particularly, the first and foremost important question is why you want to invest in real estate. Is it for your own use? Is it part of your long term investment plan? Or is it to generate a secondary and regular income? The time horizon that you are looking at and the purpose or intention of the investment matters the most here. And based on this, several other factors automatically come into play. For example, if you're planning to let out a property in India, how are you going to manage tenants being an NRI? If you're investing in commercial property, do you have the risk appetite to handle vacancy periods? And in all the cases, how do you ensure that adequate precautions are taken with respect to registration and documentation? With this context, sir, could you share some practical insights on how NRIs should think about investment rationale before buying property in India?
Real estate as a asset class has been one asset class which has been giving above par returns. If you look at last 2 decade period and probably even in a 3 decade period, the kind of returns that the real estate as an asset class has given in India sort of beats all the other asset classes in India. So this naturally makes real estate as an asset class very attractive, not just for Indian residents, but also for non-resident Indians to invest in this. What also happens is that, like Srilata was mentioning earlier, there's always an urge to probably come back and settle down in India if India was the country where you were born, or at least where your parents were born, and things like this. So this naturally sort of there is a fixed connection that gets established when an investment happens in a real estate. But over the years, what has also happened is two predominant things have happened. All the metro cities in India, if you see, are getting choked, and the availability of quality real estate has been shrinking. The demand is continuously increasing because of a migration that happens within the country for people coming all the way till the metro cities to in search of jobs. Therefore, there is also an interest that the NRIs are picking up in investing in what is typically called as the yellow zone or the green zone. What is an yellow zone? Yellow zone is something which is not exactly within the city. It's a property which is allowed, which is slightly outskirts of a particular metro city. The prices are not as high as what is available in a metro city, but it's not an agricultural or a green zone property where the end use is restricted. So there has been continuous demand, so to say, interest to some extent in these kind of properties. Now, when an asset class starts getting attractive, demand increases, naturally, people who are trying to defraud and trying to create a sense of wrong notion for people who are trying to purchase also increases. Therefore, in that sense, an NRI has to do the following two, three things. One, like Srilata was mentioning, really understand what is the investment rationale. Do I have a intention to enjoy the upside of this property, eventually sell it, cash it out, and use it for something else? Am I creating this asset class because I have deep connection with my roots? I want to sort of have a property in India, or am I looking at this as a investment opportunity to earn regular income? Or am I buying this property to allow some of my close relatives who are based out of India to be residing there? I had one case where there was an old couple. So whenever they used to come to India, one of their nephew used to take care of them. He used to make sure that they are taken care, taken around, and all of that. They decided that we will buy a property, construct a house for that nephew to stay and his family to stay. So there could be such softer considerations also, which are driven by relationship goals, which are driven by goals other than money, which could also determine when will somebody wants to invest in a real estate property in India. So first is actually determining what is the investment goal. Once an investment goal is determined, then you'll have to also figure out what is the right kind of a place to invest in. Do you want to invest in a metro city? Do you want to invest in in an area which is slightly outside of the popular metro cities and the capital cities in most of the states? Or are you looking to invest in completely semi-urban or a rural setup? Each of these decisions comes with its own complications. The property rights in India goes back to few centuries. There are property ownerships which you can trace back to nearly 300 to 400 years. So when these properties have this kind of a history in terms of ownership, and obviously the documentation around this have not been as comprehensive as what it is currently available. So there have been instances where some kings have donated lands to some of their ministers, and from there the minister's family would have held it for a couple of generations, then would have sold it later. So tracing back the ownership of all of this becomes one of the most critical aspects of buying the property. And the more the rural, the more the semi-urban, the more complications in it. There could have been joint families which are holding properties. There could be people who might not have gifted it properly. Documentation might not have been clear. In some instances, there would have been some villages which would have become towns later. Towns would have become cities. Different governing bodies would have been owning the regulatory control over these properties. So it also becomes very critical for somebody based on their risk appetite to really understand, in fact, appoint a right kind of a legal advisor to do a check back and a trace back of all the history that is available for a property before they purchase one. Of course, on the other side, you also have popular developers who would have carved out properties, whether it is sites or whether it is built up areas in the form of commercial properties or residential property, where the risk of title ownership, etc., will be lesser, provided the developer and the builders who you are engaging with are people of credible names. So the second consideration therefore becomes that you decide where to buy the property, and based on where to buy, you'll have to ensure that the kind of due diligence that you do for that property is thoroughly undertaken. The third consideration is also what is the kind of liquidity are you looking at? Are you looking at constant flow of income from these property? Because as you all are aware, real estate is a highly illiquid asset class. Because if you really want some money to be available at a short span of time, the demand supply equation comes in, and then if you try to sell it in distress, the kind of value that you realize is very low. And like again, Srilata mentioned earlier, if you have let out that property, vacating a tenant is a challenge in India. If they don't pay rentals on time, your cash flows get choked and your plans can get disturbed. So you'll have to make sure that you keep into account all of these considerations before you purchase a property in India. I understand buying a property could be partially emotional decision, but leaving it completely to an emotional parameter to decide whether I want to invest in a property in India or not is not quite feasible and should not be done. And while doing this, what you will also have to think through are some documentation aspects. So, as you all are aware, there is something called as Aadhaar, which is available in India. Now, eligibility of who can obtain Aadhaar is also something that the law very clearly specifies. If at all you are a foreign passport holder, you are a passport holder of a different country. One, you can't get an Aadhaar card. Second, you don't need one as well. There is a common misconception that you need a Aadhaar card to be buying property in India. There are situations in which Aadhaar card is also not required. Now, the second document that becomes important is a PAN card. PAN is a permanent account number, which is a tax identification number in India. The question is also whether do you need a PAN for buying a property in India? More often than not, you will need a PAN card at the time of purchasing a property in India. And every non-resident can apply for a PAN in India. And once they apply for a PAN, it is not that they are subjected to tax in India of their global income or something like that. PAN is just like a document that the authority who's registering the property, the registrars, the sub-registrars, the panchayats, the local authorities who have jurisdiction in different locations in India have been mandated by law to ask for a government document as a proof while registering a property. So you will have to ensure that you have these also at the time when you're buying a property. Last of the matter that I want to talk about in this section before I hand it back to Shrilata is to tell you that some of these aspects are not time bound. Let's assume you plan to buy a property, you liked one, you have already given, let's assume, a power of attorney to one of your relatives in India who could do an agreement to buy this property, who has blocked this property, given some advance to the seller. You decide one fine day, I'll take a flight, come to India, register, and go back. It doesn't work that way. A lot of big cities, including Bangalore, Mumbai, Delhi, Hyderabad, etc., have made prior appointments for registration mandatory, and they're all online. But there are towns and cities still in India where prior appointments are not online. So it's sometimes not transparent. So you will need somebody at the local level who will be running around to ensure that they set the entire stage right before you come down to India and make sure that the property registration takes place at the time of purchasing the property. Therefore, you'll have to keep and plan it quite well. You may need an advocate, lawyer, consultant to help you around with documentation, due diligence. At the same time, to make sure that the registrar before whom the property is to be registered has already been given all the documents upfront, who reads it through thoroughly, who ensures that there is no malpractice that is happening over there. So all these are taken care of by the registrars as well, and they also need time to be doing all of this. So you'll have to plan for this also before you buy a property.
Thank you. Thank you, sir. So once you have some clarity on your investment rationale, uh, you need to know certain compliance matters at transactional level. So that's when we move to our second section, which is on taxation. When it comes to taxation, from a buyer's perspective, it is important to be aware that tax implications can arise even at the time of purchase. Many buyers assume that taxes arise only at the time of selling the property, which is not the case always. Where the stamp duty value of a property is higher than the agreed purchase consideration beyond what is permitted under the Income Tax Act, the difference can be treated as taxable income in the hands of the buyer. And this kind of situation commonly arises due to resales, heavily negotiated transactions, and is often overlooked. Another important aspect NRIs need to be mindful of is tax deducted at source, or TDS, at the time of purchase. The TDS obligation depends on the residential status of the seller, and the compliance requirements can vary significantly based on this. And many buyers assume that TDS is a simple formality, but it is to be noted that errors or misunderstandings at this stage can lead to penalties, and not just penalties. It leads to practical difficulties later, including at the time of repatriations, which we are going to cover. At this level, sir, can you throw some lights on practical aspects where these things are usually missed out?
Yeah. So let me break down the first thing that you mentioned, Srilata. So the first thing that you mentioned is when can a buyer be subjected to taxation at the time of purchasing a property? As you rightly said, it's a misconception to think that only a seller is subjected to tax. In order to avoid property transactions being carried out at a value lower than the fair market value, what the income tax law in India has done is, in case there is a buyer who's buying a property at a value which is less than fair market value, and for this purpose, what they have said is the value at which the respective local state government is charging stamp duty at the time of registration of a property, that stamp duty value has been considered to be as a fair market value. Now, if the transaction value in such a situation is lower than the value which is so fixed by the government, the buyer is also liable to tax on the difference between the value at which they bought the property and the value which is prescribed as the fair market value for computing the stamp duty. Now, there are situations where, in order to avoid stamp duty, in order to do some transactions which are not legitimate, there could be a seller who says that, hey, let's register the property at a lower value. Let's pay lower stamp duty than what is there in the what is prescribed by the authority. Or, like Srilata was mentioning, there could be heavily negotiated properties. Somebody is in distress, they are trying to sell the property at a value lower than what the government has fixed as the stamp valuation. In this, the buyer is exposed to the risk that though they are actually the one who are paying money and buying the property, because the transaction is happening at a value lower than the value which is prescribed for stamp duty purposes, they can be subjected to tax. And mind you, the taxation is at the normal slab rates, which can go all the way up to 30% plus surcharge plus cess, all the way taking it up to 36-37% of the differential. So this puts a significant burden on the buyer of the property, and therefore one has to ensure that they are not doing a transaction at a value lower than the value which is prescribed. There are some creative advices that somebody can give, saying that how they could avoid stamp duty and things like this. Our sincere recommendation is don't fall in for such creative ideas about how this is to be done. Complying with the law makes your life easier, and you'll be risk free in all of this. Let's take for an example that there is a property for which a stamp duty value has been fixed at a certain rate, but the actual market value in that area is not that rate at all. And then let's assume there is a there is a deficiency in the title of the property, the entrance to the property is blocked by some other building, and the property behind it is being sold. You may have to negotiate with the property owner in the front to give you an access, etc. In such circumstances, based on the facts of the case and all of that, their actual value could be lower than what is prescribed by the stamp authority. Each state government has a different mechanism as to how to deal with this situation. Some state governments have prescribed an authority who could be appealed with. There are people called as district registrars to whom an appeal can be filed. There are stamp value authorities before whom an appeal can be filed before the property is registered itself, to state that, look, you have fixed a value which is so and so, but the real market value is 30% lower. So allow me to register this property at a value 30% lower. So in those situations, the respective authority may pass an order either accepting your contention, partially accepting your contention, or fully dismissing your contention. And what is the ultimate result over there will also be used for the purpose of tax computations as well. So in case of such a situation where you genuinely believe that the value of the property is lower than the value that is prescribed under the stamp rules, you have a mechanism to appeal that. It could be time consuming, slightly expensive, but certainly not as expensive as getting caught with the wrong eyes of the law. Now, coming to the withholding taxes, in case the property seller, so in our facts, it's very clear that the buyer is a non-resident. Now, based on the seller's residential status, if the seller is a resident in India, then the law is pretty clear that you can deduct a 1% withholding tax, and you will have to pay the balance consideration to the seller. And that 1% what you withheld, you will have to deposit it to the government of India. And the PAN that you have itself is a sufficient record document for you to deposit that particular withholding tax. Let's take a situation where there is one non-resident who is selling the property to another non-resident. In such a situation, the compliances goes up. The buyer has to obtain something called as TAN, tax deduction account number. They'll have to estimate the income of the seller. We have spoken in length about this in our previous webinar. Those of you who missed it can refer over there, and ensure that the withholding taxes at the right rates are made and they are deposited with the government of India. And you will have to pass on the credit of that withholding taxes to the seller. So you will need to ensure that these compliance are adhered to, and naturally you may need support at these instances. So contact your tax consultant in India who will be able to help you out with all of this. Don't take any shortcuts in either valuing the property or as far as withholding is concerned when you are buying a property.
Thanks a lot for throwing lights on taxation aspects. Before going to our third section, which is getting into funding and repatriation aspects, it's important to first understand what FEMA allows NRIs to acquire in India. So basically, NRIs are permitted to purchase residential and commercial properties in India. However, they are not permitted to purchase agricultural land, plantation property, or farmhouses. That said, if such agricultural or farmland is acquired by way of inheritance, NRIs are allowed to hold and sell it, but again, subject to FEMA provisions. Once this eligibility is clear, the next critical aspect under FEMA is how the property is funded. So this is where we get into the funding and repatriation aspects. Because this directly impacts repatriation at the time of sale. Bringing money into India through inward remittance is relatively straightforward. The source of funds becomes crucial when the money is taken out. Let's take an instance. If a property is purchased using funds from an NRI account, repatriating the sale proceeds back to NRI account at a later stage is generally smoother, subject to FEMA conditions and tax clearance, which is common. On the other hand, if the property is purchased using balances in an NRO account, authorized dealer banks typically route the sale proceeds through NRO account itself, and the direct credit to NRE account may not be available. This is why planning the funding source at the time of purchase becomes extremely critical under FEMA, as it can significantly impact the ease of repatriation at the time of sale. Sir, again, request you to throw some practical insights as to how these things happen, and give some critical points that NRIs should consider.
Yeah. So, India is one country where foreign exchange is heavily regulated. In fact, it has been, the regulations have been going down, and a lot of them have become self-regulated now. However, India wants to protect its foreign currency reserves. So, like Shilata was mentioning, FEMA is one law which sort of regulates and controls the foreign currency movement between India and outside India. It's fairly simple to get foreign currency from outside India, and a non-resident is allowed to open two kinds of accounts with Indian banks: non-resident ordinary account or NRO accounts, non-resident external accounts or NRE accounts. NRE accounts are considered on par with foreign jurisdiction accounts. That is, these accounts, you are allowed to hold currency in foreign currency or INR both in NRE accounts, but NRO are typically Indian currency accounts. When you are buying a property, when you have to make a payment to the seller, you have the following options. One, you can do a direct credit from your foreign account to the seller's account. Second, you can park the money in your NRE account, and from your NRE account, you can make a payment to the seller's account. Third, let's assume you have accumulated some money in India, you had some incomes in India. There are already money available in your NRO account, partially. Partially, you are bringing money from your overseas sources and making sure that the money is sufficient to pay to the seller. Like Srilata was mentioning, if the money that is used for buying a property is from a source within India, that is, the money is from a NRO account, then if at all eventually, if you sell this property, you are not allowed to take that money outside India. That proceeds of the sale will be locked up in India. One may argue, hey, I have paid the taxes. Why should somebody stop me from taking it? This is a regulated subject. Like I said, government has its own reservations about money moving out of India. Therefore, FEMA laws are there and regulations on that are there. Money will not be allowed to move out. However, if the payments are from your NRE accounts or foreign currency accounts of in foreign jurisdiction, then repatriation becomes easy. Now, if the money goes into your NRO account, is it totally locked up, not permitted at all? No, the answer is still you can go to the Reserve Bank of India and ask for allowing you to repatriate, but more often than not, such permissions are not given. Therefore, at the time when you are investing in a property, you will have to ensure that the sources of money is also correctly planned and is reflective of your ultimate usage of that property and selling that property. Further, like Srilata said, you are not allowed to buy agricultural land, plantation lands, and farmhouses in India. You may argue that, I have roots in India, I'm a OCI card holder, etc. None of it is valid. You're not allowed to procure these kind of properties at all. But if you inherit means at the time of demise of a legal representative, of a legal hire, and the legal hire, the downward legal hire inherits a property which are in the form of farmhouse, agricultural property, etc. Those are allowed. You can maintain them. However, gifting, receiving of a gift, let's say you have your brother who is a resident in India. Your brother has a agricultural land in his name. Let's say your mother is a resident in India. Your mother has an agricultural land in her name. They can't gift it to you also if you are a non-resident, if they are an agricultural property. Only by way of inheritance you can acquire it. You cannot acquire it by way of a gift also. Though gifts are not taxable as per income tax law, FEMA doesn't allow you to get them as gifts. This, however, said that even gifts of non-agricultural properties, let's say commercial or residential property, may have some taxation in the hands of the receiver in the respective jurisdiction where they are resident of. There are estate taxes, there are gift taxes which are there in other countries. One has to be very careful while receiving those gifts, despite the fact that in India they may not be taxable.
Yeah. Thank you, sir, for your insights. And in addition to this, I just want to pose a quick question, which is what are the additional compliances that would be there in an NRO account when compared to NRI account, so that the audience, for the audience, it would be helpful to understand.
Wonderful. So, like I said, two kinds of accounts can be opened. NRO accounts, all your India credits, any incomes arising from India, rental, interest, dividend, if at all you have shares, etc., it can go into that. The interest earned by the funds which are lying in the NRO account, it could be an NRO FD, it could be NRO SB account. Both of them are taxable under the Indian tax law. So you may hold just an NRO account with some funds in India. If the interest is exceeding the basic exemption limits in India, you'll have to mandatorily declare those incomes in the income tax returns, and you'll have to file tax returns properly, because banks might have also withheld taxes on those interests. But if you hold a NRE account, non-resident external account, whether in the form of FD or SB, interest from those accounts are not taxable in India. There is an exemption for that, and you are allowed to maintain those accounts and earn interest on that without paying any taxes. On returning back to India, there are rules as to till when can you continue to hold your accounts as NRE. When do you have to get converted? That is not a subject matter of today's webinar for us. We will hopefully curate one such webinar in the future, talking about all of these for individuals. But you keep a tab of what kind of interest that you're earning in India, and make sure that you're compliant in India by filing tax returns in India. Filing tax returns in India through a well educated, aware consultant for a non-resident is pretty simple. Missing that is actually very dangerous and difficult. So our sincere advice is, if you have some accounts in India which are earning interest incomes, it may be dormant, you may not have used it. Do not neglect it. You never know when the need of that will arise. You may sell a property which you inherit, you may inherit a property, you may want to buy a property, or you may eventually, after some time, want to come back and settle in India. Having your records clean is going to be that much more peaceful to you, and year on year compliances are pretty simple and smooth. Our recommendation is you carry them out rather than missing them and suffering, at some point of time in the future.
Yeah, agreed. Thank you again for the explanation, and importantly, those critical highlights which are very relevant for NRIs as taxpayers. From all the sections that we covered today, starting with the investment rationale and then critical taxation aspects, and the most interesting FEMA regulation and repatriation points, it can be noted that while investing in India, Indian real estate can be a rewarding opportunity, it's equally important to approach it with clarity and proper planning. What happens is things that are missed out in buying decisions can impact even at the time of exit or sale. So it's important to plan and comply with requirements at an entry stage itself. With this, we have come to the end of this webinar session, and we hope the session was informative. And if you have any further specific questions on any area, you can reach out to us via a mail to support@advaititech.in, or you can reach out to us through our website or put your comments on our social media platforms. We will reach you back. And stay tuned for our upcoming learning sessions with practical aspects. Thank you all once again for joining the session. Meanwhile, if you want to know more, you can visit our website, read our blog, subscribe to our newsletters, and stay updated with key finance insights. Thank you, one and all. Thank you.
Thank you so much.